Hello. Welcome, welcome. I'm gonna let people log in and get started in just a minute. Good afternoon, everyone. We'll get going in just a sec. Right. Good afternoon. All right. I will talk slow and get us started as everyone's logging in. Good afternoon, everyone. I'm Emily Hegarty. I'm the program director here at the Napa Valley Grape Growers. I'll just get us started with a few housekeeping comments. First, and most importantly, I'd like to take a moment to recognize our annual sponsors that you see on screen here. They are a great support of our organization, and we encourage you to support them in return. Attendees, if you have any questions, you are welcome to submit them anytime in the Q&A box, and Erica will go over them at the end of her presentation. And keep in mind that this is being recorded. I'm sure the little AI voice told you that when you logged in. So no need to take detailed notes. We'll be sending you the recording and slides after the presentation. So with that, I will introduce Erica Rosasco. She's the owner of Rosasco Law Group in Rockland, California. They represent employers, businesses, and nonprofits in all aspects of civil and employment litigation. Erica has been named the last 7 years as Super Lawyer of Northern California. I'm going to use that every time you speak for us, Erica, because it's the best title. She is a board member of the California Farm Labor Contractors Association and Agricultural Personnel Management Association. She has a wealth of knowledge. We are very appreciative that she's here this afternoon to help you understand the legal pitfalls under the Private Attorney General Act, or Attorneys General Act. So with that, Erica, I'm gonna let you take it from there.
All right, thank you. I will go ahead and post up my slides now, so hopefully you guys can see that.
That's great.
Oh, perfect, great. Okay. So I want to go through this this has been on my mind to do for quite some time, so I'm really, really pleased that you guys showed up to listen to this because there's a lot of information that I have that you guys need to know. Because as a lot of you on the line already know, look to your left, look to your right. If we were sitting in a room, right, I would tell you that these are the people that are going to be in a PAGA lawsuit within the next year, maybe two at the most, if they're not already in one. These PAGA lawsuits, the Private Attorney General Act, are sweeping through California and particularly sweeping through the Napa Valley at a rate we've never seen before in our entire careers. It is just like nothing we've ever seen before, and there's a lot we can do to perfect ourselves to make the cases defensible. You're not going to like it, but it'll be defensible. That I want to share with you guys because it's pretty simple stuff, I think, for the most part, but stuff that we easily overlook or overlook how tragic the results can be by not following some very basic things. So I want to kind of distinguish the different types of lawsuits that you guys are going to see. Typically, you're going to see individual lawsuits. Those are actually fairly rare by comparison now. So we hardly ever see a case filed on an individual's behalf. In fact, the plaintiff's attorneys prevent that from happening. So the vast majority of plaintiff's attorneys are all down in LA. And they know that the attorneys will make more money, far more money, in any class action or PAGA case. And so they rarely will allow a case to be filed on an individual's behalf unless maybe it's like sexual harassment or something really juicy. They're not interested in the fact that all of your employees would benefit far more on an individual case than they will ever benefit from a class action or a PAGA case. The reality is your employees are being used as pawns in the LA lawyers' game. So individual cases, those typically you're talking $20,000, $30,000. And if it's a $30,000 case, the plaintiff's attorneys aren't really interested in that because that would only mean, about a third of that goes to them or maybe half, $10,000, $15,000. Why would they do that when their smallest PAGA cases is going to get them hundreds of thousands to millions of dollars? They won't. And they will not adhere to their ethical duties of informing your employees about what their basic rights are, how they will benefit from an individual case, what they may be giving up in filing a class or a PAGA case. They simply don't tell them. And in fact, when we pull your employees into depositions, 100% of the time, your employee is under the impression that that case is filed for their own, particular grievances, not on behalf of everybody. It's very, very rare. They'll have been prepped well to know to say, no, it's a class case. And even I've questioned employees before and said, do you know what that means? Well, no, my lawyer told me to say that. Thank you. Right. A class action, that means that's one employee, right, who's going to put their name to a case, one or more, and they're going to be able to go back 4 years and they're going to grab not only that employee's grievances, but every employee that's worked for you for the last 4 years. So that's a lot of people. And they have to be similarly situated. So maybe they're subject to a rounding policy, a late meal period policy, working off the clock, those kinds of things. But they can go back 4 years. And in a class action, you have statutory penalties. Those are things that cannot be reduced by a court. So, like, for example, one of the big penalties that comes up is 30 days of waiting time penalties. And for us in Napa, that's about $4,000 or so per employee that's ever worked for you. So Napa and Sonoma areas, think about that as $4,000 because it's a minimum of a day's wages for every day they go unpaid up to 30 days. So that number usually gets me, if you look back at how many employees have I had in the last 4 years that have been laid off or terminated, multiply that by 4,000, that's your waiting time penalty class alone. So do some math. Think about how many W-2s you've issued, right? So we hate class actions. The only thing that's good about class actions is there are some protections in place. The individual has to be a good class rep. So a lot of the people who file these cases, lo and behold, are criminals. No joke, can't leave the county. They've got an ankle bracelet on. Oh, they're serving time in jail right now, right? But the court lets them look for new plaintiffs on class actions. So 25 or more employees basically to even think about having a class action. So if you're a real small business, and that's not going to matter to you, but the next one will. PAGA does apply to any size employer. So the Private Attorney General Act, that is otherwise called the Sue Your Boss law. That allows any employee who's ever worked for you for a single day to sue you on behalf of all of your employees, whether they consent or not. They cannot opt out, like in a class action. They are bound to this. PAGA cases can only be resolved in court. And we really don't care if the plaintiff is a piece of shit. There's no requirement that they be a good, decent human being. And because it can only be resolved by a court, right? I can't go around picking off those claims very easily. So the good news is on a PAGA case, it only goes back 1 year, and then it will continue moving forward until that case gets resolved. And PAGA penalties can be reduced by the courts in the interest of justice, and they quite often are. Depending on what jurisdiction you're in, depends on my confidence level and how much of a reduction we'll get and the types of violations that we made. But in all of these cases, in any one of these, the attorney will get, not us ever, never, ever, ever the defense, never the employer, but the plaintiff's attorney, if they get $1, they're also going to get their attorney's fees. So we often say that these cases, it's the tail wagging the dog because they're attorney's fees driven. And I'm often sitting in mediations having to explain that we are not there about the case. We are there about how much it's going to take to fill plaintiff's counsel's pocket for them to go away and stop driving up attorney's fees. So nothing about this process is fair or reasonable or just. There's not a lot of justice involved here. This is something that with the PAGA cases is unique to California. We've gotten some law changes to PAGA that are going to help us moving forward. So if you don't have an existing case or you got one that was filed after, gosh, right around June 18th, something like that, then you're going to fall under new PAGA. New PAGA is only going to help you if you follow the steps we're talking about here today. So it used to be that I would talk to you guys about, doing really well, doing your best, getting mostly things right. We were talking about, 50, 60% violation rates, right? Now with PAGA, we've got to talk about perfection. So I need perfection in your records to get rid of that case. And it's still going to cost you far more than you would even imagine. So you're not going to feel like the winner at the end of the day. In my first line of defense, and I cannot stress this enough, if you have more than 25 employees, you have to have an up-to-date arbitration agreement. And for us in ag, we've got to have it in English and Spanish. The benefit to having an arbitration agreement is, arbitration makes it private. It's faster than staying in court. So you can't really learn much about what happens in the goings on of arbitration. They completely stop a class action. So they won't stop that individual's case, but it will stop a class action. They're not allowed to maintain one. If you have an up-to-date arbitration agreement and your records look perfect under new PAGA, I can force that case into arbitration, defeat the plaintiff there, and the case dies. They never get to see your class list. They never get to do discovery into the rest of your company. I can really kill that case if you're doing all the things that I asked you to do here. And I am going to share these slides with you because I want you to have this, post it up, live by it, right? Yes, you can make arbitration agreements mandatory. I know there's been a lot of back and forth about that. If it makes you really nervous, I'll do an optional one for you. But you can make it mandatory unless you're under a current lawsuit. Then we would have to do a disclosure and make an optional one for folks that fall under that lawsuit, under that pending lawsuit. But otherwise, we make it mandatory. My partner, Mike, loves optional because he just thinks it's unbeatable in court if they sign it. And if you give it to them in an onboarding package, right? I'm signing. It's not a big deal. They get signed. We've got a really good compliance rate with that. I like mandatory because over the years, I feel so burned by just things falling through the cracks and people not signing them that I don't trust anyone anymore. These employees will rob you when given the opportunity of everything you've ever worked for. So To me, I, would say if you want to work here, you've got to sign this agreement or see you later. And the feds have backed us up on that. So that can't be a California decision. That's a federal decision. That's a done deal at this point. So I'm very comfortable doing mandatory. We fight these arbitration agreements in court all the time. As long as you're not using an old one, then you're going to be on solid ground. So if something got denied, it'd really be an appealable issue. Not fun, but something we could appeal. Downside of arbitration, it is very expensive. So this is the part where I said you're not going to feel like the winner. To take your case in arbitration, I'm going to spend about 100 grand with that arbitrator on the arbitrator, not on me, right? Just for the arbitrator. But if I kill that case, no PAGA case typically is going to cost you less than 100 grand. These guys have been coming in, and for example, this week we got a $10 million demand. We left that mediation. They were at $9,960,000. And if you think that lawyer is any different than you, think again. They're not. Remember, I represent folks in ag. So my clients are exactly like you, and no different than you. It wasn't somebody who tried to do something wrong. In fact, I'll kind of dig a little bit deeper into that in a bit, about how just wonderfully well they had done things. So you cannot stop PAGA in an arbitration agreement. So that will go on, but PAGA is a year. We can get reduced statutory penalties. We've got some more benefits coming up for that, that we can take advantage of. And you can't use it for sexual harassment or discrimination cases. Not great, right? I don't love trying a sexual harassment case in front of a jury in the post Me Too era. But PAGA cases are, if it, were to get past arbitration and go back into court, those at least are a court trial, meaning that's going to be tried by the judge, not a jury. So that there's a little bit of benefit there. I feel like judges are going to be a heck of a lot more reasonable than our post-COVID juries that are insane. So remember, 10% of your jury pool believes the world is flat. They fully believe and embrace in conspiracies now that they wouldn't have before COVID. So the landscape for our jury trials has changed dramatically. Okay, so what can you do? Get an arbitration agreement from your attorney. Make sure it's up to date. Expect changes frequently. If you're on my email list, we always put out articles and stuff when we've done an update to one. We used to try and send them out to you guys, but now there are just too many of you that we've done them for, so we can't do that. Yes, you'll hear arbitration agreements that are mandatory can be a misdemeanor in California, but it's not enforceable. That's been blocked. So your arbitration agreement needs to be signed by you and the employee and dated. You can use an electronic signature, but it has to be authenticated, meaning you're going to have to be able to give me a declaration from somebody authenticating that signature and proving it is unique to that employee. If you can't do that, then use a paper one. So really no excuses not to have one. Arbitration agreements cost a couple $100. They're really, really cheap. There is nothing else that's going to crop up for you that is as cheap as that. So best deal in town. These lawsuits all really originate from some type of employee offense, upset, minor issues. So it's important to me that you guys are training your supervisors when you've got a problem employee that maybe they're not dealing with it on their own. Maybe they're raising that to our attention so we can deal with it. There are a few instances where I've thrown up my hands and said, you know what, we're getting sued, but they got to go anyway, right? But we should try and do everything we can to not have employees feel like they were mistreated or wrongfully terminated or terminated in a disrespectful manner, right? We need to be very conscious of being respectful and treating other people the same way we would want to be treated, and getting those employee upsets addressed before they go running off to a lawyer. Remember, there are algorithms right now. The minute you're upset, your phone's listening to you, your Alexa's listening to you, Siri, all these things, right, are listening to us. The minute they hear us talking about these things, it pops up in our algorithms, right, for all these lawyer ads. And if it's not popping up in the ads there, then they're getting text messages and phone calls and letters in the mail soliciting them, even though not legal. We have to catch the attorneys doing this and turn it over to state bar and then hope they do something about it. So not one of these employees is going into a lawyer and saying, I want to file a class action. I want to file a PAGA case. There's no way, because they only get a small enhancement award. So if you got $1 million PAGA case or $1 million class action case, your employee is only ever going to get between $5,000 and $15,000. So if they had an individual case, right, it would probably be worth tremendously more than that, but nobody's educating them on that. All these cases really originate with what happens with our supervisor. They are our first line of defense to a lawsuit. What I see is a lot of old school supervisors who are trying to do their best for the company, who have the company's interests in mind. But that old school mentality tends to rub people the wrong way. And so they might not be able to deal with conflict well or give positive feedback, to give corrections in a respectful manner. So it's important that they know when to ask HR to step in, to have a third party step in, right? To be respectful. The other thing that upset our employees is if they see favoritism. So we don't want supervisors supervising other family members, a girlfriend, a mistress, whoever it is. We want, even though favoritism is not illegal, nepotism is not illegal, it causes upset, it gets people calling a lawyer, right? Um, if they've got a workers' compensation case and they don't feel like we're handling it well, we're not, we're stonewalling them, they're not getting medical treatment, that might send them to a lawyer. So we want people to feel like, hey, we're listening, we're here to take care of you, we want the best for you. If something's not going well, tell us and let us help you, right? Over and over and over again in lawsuits, I see the same things: snapping fingers to hurry up, references to being old, being told to hurry up or they're too slow, derogatory phrases or innuendo. People get very, very offended and 100% will go to a lawyer about it. And the lawyer could care less what that employee says. They may or may not even really be asking them about all these wage and hour issues. A lot of them just throw a kitchen sink at the wall, right? List and see what sticks. So, you don't even have to have the employee doesn't even have to think you've done something wrong, right? It's also really important for me that you guys do a good job documenting. If we don't document, it doesn't exist. So I really want you documenting how an employee goes to leave us. Did they quit? Were they upset about a particular issue? Did they say they were going to fraudulently sue the company? Did we document disciplinary issues and poor work performance? We're also being fair here, putting the employee on notice. Hey, you're falling below standards. Hey, here's what I need you to do to improve. We treat people like we would want to be treated, right? Follow that progressive disciplinary path if you can. Don't promise it. But hey, give it a verbal, a written, a sit down, right? Maybe a suspension. You want, if it comes to a termination, if we're not going to bring you back, you don't want that to come as a surprise. If you've got slow workers and there's anything objective you can look at and document, how, hey, they're falling, X number of plants behind the rest of the crew. They're following however many rows behind the rest of the crew. Can you measure that productivity and give warnings about it, or offer a different type of job that they might be better suited to do? Okay. You want to document at or near the time of the events. pull that objective data when you can, document consistently. So don't just pick on the pregnant ladies, right? You don't want to do a whole lot of back and forth text messages or emails. If you can, do the face-to-face discussions. Things go so much better in person than in email. Email tone is often lost. And then watch out for defamatory statements, right? And if there is text messaging, take screenshots because I'm going to need those later and I don't want them to get erased. And then watch out when you've got protected categories, disabilities, a protected class, protected activities, anybody who's complaining about their wages, hours, working conditions, that puts them all into our protected category and they know it. And that's what sends them running to a lawyer. So you guys need to make sure you're calling for help when you're dealing with a problem employee, when it involves things like somebody who may feel retaliated against. Did they take a protected leave? Were they in a protected category? If they came back from a leave and their job wasn't available, if they requested an accommodation, they've had that work related injury or injuries. Those all put very commonly what we see will send people out to a lawyer where we end up with these cases. 90% of the time, you guys have a warning shot across the bow that a lawsuit is coming or is about to be filed. So, and a lot of times when we get these records requests in, that is to explore whether to file a PAGA class action case against you. So don't respond on your own because you guys will turn over everything they ask for, right? Make sure you get your lawyer involved. And then we've got some tricks, right, to play along the way to make sure we're giving records out to the right person, not giving it out on somebody who's not interested in the case, and not giving more than what is legally required. If we don't respond to a request for records and personnel files, it could potentially be a PAGA penalty. Now, if you already have a million others, it doesn't matter. But if your records otherwise look perfect, we don't want to let this be the mistake. You have 21 days to produce payroll records and 30 to produce a personnel file. But we want to make sure we have employees' authorization, identifying information, and again, not giving more than what we are legally required to give. So you wouldn't turn over things like an investigation file, a handbook, probably time cards aren't going to go. We don't necessarily have to send paycheck stubs. We could do a payroll summary. So lots of little things along the way that we can do to protect you. We can check the court files to see if something has already been filed. Sometimes it shows up, sometimes it doesn't. The other thing that's happening a lot now is you have some of these bottom feeder firms that have now realized it was the ones that were just doing like, hey, can you give me a buck? Can you give me a buck? Can you give me a buck? And they were just taking every case that came through the door and trying to scratch some money out of it. Well, now what they've done is they've split it and they're doing a workers' compensation case and a wage and hour or some type of individual case along with everyone, and then selling that case if it could be a class or a PAGA case. So when you guys are getting in these workers' compensation subpoenas, particularly when you know the case is fraudulent, but even if you don't, that employee may not even realize that lawyer is taking those records and selling them on to have a case filed against the employer. So what we respond to in that subpoena could be used against us to drum up a case against us or to at least sell that case against us. So be careful about producing records in response to a subpoena. I suggest you get your wage and hour attorney involved, not your business attorney. Business attorneys don't practice in this area of law and don't know what the risks and pitfalls are or the things that we can do to protect you. Terminations. So we have a tendency to bury people in a layoff when we want to get rid of them. And then when we don't bring them back, it used to be 1 in 10 would make an issue of this. Now I would say it's at least 9 in 10 that will make an issue of it. So if we've got somebody that we don't want to bring back, we need to make sure that we take steps to terminate them and let them know they're not going to be invited back rather than trying to bury them in a layoff, because it makes it look very suspicious, right? You want to use that notice of change in relationship and spell out why somebody is leaving us. Were they a no call, no show? Did they leave to Mexico and never come back? Were they a seasonal layoff and you told them when to return? Or were they terminated for cause? And we gave a brief explanation as to why. Sexual harassment cases, remember, it is strict liability for all, foremen, supervisors, everybody on up, right? Owners of the company. You got to be really, really careful here that you are not letting folks date in the crew, right? It should never be a subordinate to a supervisor type of relationship. Even with owners, I've seen it happen. So you probably are not aware. Some of you are, I know, that are on the phone, but people are using being a victim of a crime to claim citizenship. And by doing that, they're claiming rape. So you don't want to work alone with somebody who might claim rape. You don't want to be in a vehicle and alone with somebody who might claim rape. You got to really protect yourselves, because in each instance, I've seen this happen, and I have seen it happen multiple times, including in the Napa area. The gentleman went to jail, whether or not he committed that act. And I happen to know in several of them, he absolutely did not. So they spent about an average of 6 days in jail before they had to hire a criminal attorney and find a way out. So careful there. When your employees are in crisis mode, right, we got to do what we can to help them by driving them to their work comp appointments, helping them with the carrier to making sure they're getting their medical appointments, communicating with them about the claims process, offering leaves when available. When you don't, they will go to a lawyer over that, and that's what triggers your PAGA case from happening. When somebody goes to leave you, sometimes we want to offer them a severance if we know they're a problem employee. Severance agreements will not stop a PAGA case, or they will not stop an agency case. But in the agency cases, they will have waived their damages. And your employee pretty much is going to think, okay, the issue is resolved, right? I've got one case. I've had two in my career where they tried to go beyond the severance agreement. So it's usually money well spent when you know you have somebody who is a problem. When you're going to offer a severance agreement, I always say you got to have a backup plan. What's plan B to that, right? In case they turn the severance down. You really want people to know that you've got a good, solid open door policy where people can come and talk to you if they can't talk to their supervisor, if it's their supervisor who's upsetting them. You want to have names and phone numbers in your handbook, including your sexual harassment policy, so that people have no excuses of, not knowing where to go to get help. And then making sure you're addressing sensitive situations in private, never, ever, ever in a group embarrassment situation. All right. New PAGA. How can we lean into new PAGA and work it to our advantage? You need to do frequent wage and hour audits. So you can have a lawyer do them. You could have an HR company do them. You can do them yourself, but you need to document them. We don't have a specific time period. I would suggest at least quarterly. If you've got problems with your payroll records, if you're trying to get piece rate right and can't quite do it, right? Maybe it's weekly until we get some perfect checks out of that, right? At a minimum, right? At a minimum, we want to make sure we're having a paycheck stub and a time card looked at. So I always tell people, look, if you're on a budget and you don't have a lot of money to spend, do a paycheck and a time card. Give me your most difficult paycheck. Give me something with overtime and different pay rates, maybe with piece rate. And then you're going to benefit from PAGA because it takes $100 penalty and it automatically reduces it to $15 if you did make a mistake. So that's a huge reduction. I don't have to then fight with plaintiff's counsel about it, right? In the new case, new PAGA, the plaintiff actually has to have suffered an injury. So that's why I say I need your paperwork to look perfect. I'm not going for good anymore. I'm not going for great that I would have taken 4 or 5 years ago. I'm going for perfection, especially on paper. So give me that perfect case. We'll pull it into arbitration and we'll kill it there. Hopefully we can talk the plaintiff's attorney into going away before we have to pay that arbitration deposit, right? Those deposits are $80,000 to $100,000 once you get a little bit into that process. So, TikTok on that, right? Goes up pretty quick. If you're going to venture into piece rate, you need to have it checked by an attorney, and I would say yearly. When I know clients who get sued that are doing piece rate, I gotta tell you, I get real nervous. And the first thing is, okay, did the plaintiff do piece rate? Right. And then let me see the piece rate because I gotta see if you did it right, because piece rate is very rarely done correctly. Can be, but it's very rare, very, very rare, and not without some tinkering from us typically. So I wanted to give you kind of an example about how these cases can look and add up just on a PAGA case, right? So this was a shining example of a wonderful client who does everything right, but they had just tiny, tiny, tiny percentages of error. Meal period violations that were either late, short, or missing, 1.24%. So that happened with 1,637 paychecks. Tiny percentage. It's worth $163,000. Rest period violations. We had a lot more there because we were recording rest breaks and not recording all of them. So in that one, we had almost 6,000 paycheck violations with missing rest breaks. So, it goes by how many times you paid. It won't be now weekly. They'll give us a credit for that. So this was $586,000. Overtime, we didn't calculate it right because we didn't pay it as a weighted average, which we're going to talk about here in a minute. So another 100,000. Well, when you do these things wrong, now your wage statement's wrong. So that occurred 4.2% of the time. Another $600,000. So because we issued 5,000 paychecks with these little things wrong with them, right? And then, you paid late. And so you get double penalized on that. So overall, this client had, a 4% violation rate or less. 4%. Almost $2.3 million is what it's worth. They're no different than you. Go look back last year. How many paycheck stubs did you issue? And you can scale that down to what your exposure could be. So to give you an idea of what this looks like. It's really important to me that you guys do field access training. You keep social justice groups away from your farm workers. They are in your area. You've got North Bay Jobs for Justice. We've got union groups running around, playing a lot of illegal games, right, to get our employees to sign on to things. I've got a case where this big class action law firm, has been around for a long time, has now hooked up with the UFW. And in that case, we picked off all three of the plaintiffs and they said, don't worry, we've got 18 more that have signed on. And I said, you mean you've got 18 more people you duped into signing a card for a union? Let's see if they come through or not, right? So you want to make sure you're informing your employees about these scams. Hey, be careful. People are trying to scam money out of you. So, employees need to know what their rights are and that people might be trying to get money out of them and not to fall for it. The other thing we're seeing is what's called cappers. So people who are soliciting your employees to file a lawsuit against you. not because they think you did anything wrong, but because they're telling the employee, hey, just say this. If you say this, you're going to get a lot of money. You're going to get $36,000 and it'll be within the next 3 months. A total and complete lie, mind you. So the person then sells the case, illegal, and then somebody buys the case, right? And then they do a poor job of trying to bring that case around to get money out of you. And then they do social media campaigns. Anybody guess how much one lawyer down in LA spends a month on these social media campaigns? $1 million. One single lawyer spends $1 million a month on these campaigns. Another one is doing $1 million a month on the Spanish radio advertising. So that's 2 lawyers. There are hundreds, if not thousands, down in LA doing this. You also have all of your personal injury attorneys. Cars have gotten safer. They have less personal injury cases. There are cameras everywhere. They can't do the old fake slip and falls anymore, right? They can't claim these soft tissue injuries anymore because the cars are braking for you. And so what do we do with all the ambulance chasers? They found PAGA. So they're all becoming PAGA lawyers. So I just got last week a letter from Jacoby and Myers. And if you go onto their website, they don't talk about employment law, but hey, why not throw your hat in the ring and we'll just collect these hundreds of thousands of dollars. This is easy money for them, right? Easy money for them. Make sure you're taking care of your problem employees, right? The ones that drive the rest of the crew crazy. That shows the rest of your employees that you care and you're listening to them. Keep your pay practices simple. So in ag, we are very unique in that we come up with these complicated, crazy pay structures. So the more complicated your pay structures are, if you're not paying one rate all of the time, it leads to problems. So in ag, we pay $1 more for this, $2 more for that, an incentive bonus for this, right? We throw all kinds of different pay practices in, and then we just hope and pray that it's okay, and it never is. So I want you to rethink about how you're looking at overtime. Overtime is a penalty because the courts and the legislature don't think your employees should have to work overtime. And so they want you to be penalized from it. So think of it as a penalty. It's the regular rate of pay. It is a weighted average that can only be calculated at the end of your work week. You can never calculate overtime by the day. You will be wrong. You will be wrong. Okay. If you are looking at total compensation for the work week, throw it into your bucket, right? Wages, piece rate, rest and recovery pay, non-discretionary bonuses. You do X, you get Y, you get this bonus, right? That all goes into your bucket. You divide it by the number of hours worked, and that gets you your RROP, or your regular rate of pay. We don't put in our bucket things we didn't work for, like overtime premiums, meal or rest period premiums, right? That stays out of it. Paid sick leave, vacation, a Christmas, unexpected bonus, that doesn't go in there. So expense reimbursements don't go in there. That all stays out of it. Oh, split shift premium doesn't go in there. And true gifts. Don't call it a gift when it's not a gift. Think you're going to get away with it. That doesn't work either. So that regular rate of pay, you're going to use to pay overtime premiums, sick pay, meal and rest period premiums. So if you don't give a meal or rest period, or if you give it late, interrupted, and reporting time pay. You show up to work and you're not given half your usual or scheduled shift. And you got to pay between 2 and 4 hours of reporting time pay. It has to be paid at that regular rate of pay. Sick pay can also be calculated at a 90-day average, which is even better if you have a payroll system that is capable of doing that. So let's look at some examples to see of how this rate system really works. So here you have Rip, who's working 1 day in the work week. He earns $16 an hour for 10 hours a day. Easy peasy, 8 hours, $16 an hour. His overtime rate's going to be $24 an hour. That's how I want you to stop thinking about overtime. I want you to think about it in terms of the premium method, the one below, where I work 10 hours at $16 an hour, plus I get 2 units of a penalty at $8 an hour, right? So my premium amount never changes through the work week, no matter what rate I'm working at. So we'll look at a few more examples. So let's look at a little more complicated work week here. Rip works 9-hour days for 45 hours total. He earns $30 an hour for the first 2 days, 16 for the last 3 days. He also gets a non-discretionary bonus of $2 for every hour he worked finishing the season. Under this premium method, right? This is what I want you using. This is what the attorneys have a hard time even understanding. The payroll companies don't understand. So 18 hours at $30 an hour, 27 hours at 16, right? That's your base hourly pay. I've got my bonus, 45 hours at $2 an hour, my overtime premium, right? I'm going to take all my earnings for the work week, divide it by 45. That gives me my regular rate of pay of $23.60. Half of that, the overtime premium, is $11.80 times your 5 hours. So it's broken down, right? But wait a minute here. Was that a flat sum bonus? So you want to encourage your employees by staying through the end of the season. So you promise them an extra $200 if they work through October. So wonderful. You guys did something nice. What happens? You're going to get sued every time you do something nice, right? We do it wrong. So a flat amount of money like that, $200, it's not piece rate, not production bonus. That is going to be treated a little bit differently. Any flat amount of money, so that $200 seasonal bonus has to be, you have to go back and recalculate overtime for the whole season it covered. And we put it into our pay, right? We divide it by not total hours worked, but regular non-overtime hours worked. And then we pay that rate by 1.5 because the bonus itself, right, didn't have the underlying rate already paid. Doesn't really make sense. Doesn't follow the logic, but it's what the court says. So we'll play their game on this one. So if you look again, whoops, because it was a flat sum bonus, we actually did that wrong, right? We paid the $90 bonus here, right? But we have to adjust it for overtime by going back through and paying it by 1.5. So you see a little bit difference in pay there. That tiny difference in pay makes a difference between being right and wrong. So we've got to adjust it again. Remember, we don't want to round anymore. A court decision just came out within the last year or so that says to the extent we have to pay, we can pay by the minute, we can track time by the minute, we have to. Yes, you could technically overpay an employee, but we really want to see a lot more variations in time. I want to see a lot more little bits of overtime being paid. So if we always say we start at 7 a.m., then maybe I see we worked 5 minutes of overtime, 3 minutes of overtime, 5 minutes under what we expected, right? I want to see a little bit of variation in that time, maybe a little bit of variation in our start and stop time for our meal periods, assuming it's always 30 minutes, but maybe I take it at 4 hours, 15 minutes in my shift, 4 hours, 20 minutes in my shift, 4.5 hours into the shift. Seeing little variations on that will help us a lot with these blockhead LA attorneys who don't get how ag works. A meal period that is short by a minute is late. Like it's as if you never gave it. So you can't round meal periods. They have to be a minimum of 30 minutes. They need to start well before the 5th hour. So that means I need you taking your meal period, your first one at 4.5 hours into your shift. your second one at 9.5 hours into your shift. If you give too many, it's okay. You give not enough, it's not. This little chart tells you how many meal periods are due and rest periods are due. And what happens is if you guys go a minute over 6, you fail to give your second rest period, right? I don't like waivers in crews. So I know you can waive your meal period if you stop by 6 hours. But what if I go 6:01? It's no longer waivable. It had to be taken before 5. Now I'm late. I owe the penalty. 1 hour of pay at that weighted average of pay. If you go over 10 hours, right, I really want that second meal period taken by 9.5 hours. What most of you will say is, oh, we waived it. We were going to stop between 10 and 12. Okay, but you can't waive that third rest break and you forget to give it because you never hit the time of day that you might normally take it, or you just think, well, it's a waiver, right? No, we don't waive in groups. We shut all the operations down and we make sure everybody takes them, including the tractor drivers, including the irrigators, right? We've got to impress upon any hourly employee that they must be taking all their meal and rest periods. So this shows you how many are due, not when they are due. So, does the law require you to document rest periods? No. Do I want you documenting rest periods? No, because you guys don't do it properly. I tend to find a rest period case is entirely defensible. Okay, I can win that case unless you are documenting it and you're not giving enough. For example, that 6-hour and 15-minute day. Most of you will have one rest period, one meal period, and that's it. And it's wrong. Now I've got my violation. Now the whole PAGA class is in play. So I can't defeat it in arbitration. So some of you have great payroll systems that, account for every minute of your day, and you're going to put rest periods in there. That's fine. Then I need you to recognize that this happens, and somebody needs to be held accountable that we are double and triple checking our time cards to making sure that all rest periods are being given, or we're paying a rest period penalty for that day to wipe that off the books. Remember, your rest and meal periods have to be duty free. You can't tell them they cannot leave the property. Tardiness is a disciplinary issue. Don't lock gates behind them, right? They're free to do what they want, and they get a minimum 30-minute meal period. And it doesn't start till they get out of the field, till they put their tools down. Same thing with rest periods. Walking time is our time. That's paid by us. So if we mess something up, it's going to happen. That's okay. I want to see some meal and rest period premiums paid throughout the year. Pay a 1-hour penalty per day for a meal period penalty, no matter how many you miss or mess up. And same thing with rest periods. You mess up a rest period, pay 1 rest period penalty per day. Separate lines on the paycheck stub. Get credit for that premium you paid. And again, I could win that case, right? A lot of you use really expensive payroll companies and you rely on the fact that they're going to get this right. They don't. I've never seen a single paycheck company get it right out the gate without some serious work by us in getting it there. And I have sat in these sales pitch meetings more times than I can count. And every time they come in and they give me the dog and pony show about how compliant they are, and we work in ag, we work with lots of ag employers. And then I've never heard this before, and I don't know what you're talking about, right? Big red flag. So if they don't have a units column on their paycheck stub, then you shouldn't be doing piece rate because you're probably not going to get it right. So you can't round peg, square hole paycheck stuff, or it's not going to come up correctly. Okay, what needs to be on your paycheck stub? You guys have gotten a lot better at this, I will say. Gross wages earned, net wages, total hours worked by the employee, all deductions, right? Inclusive dates of the pay period, employee's name, the last 4 of their social. Don't use an employee ID number because the DOL won't let us know. The employee's address, that's not a PAGA issue though. Here's a big one. The grower's full legal name and address. For every grower you send, if you're a vineyard management company or a farm labor contractor, every grower that employee goes to has to be listed on that paycheck stub. You should have your employer EIN number on there. It's just a DOL issue, not too bad. All applicable rates of pay and corresponding number of hours worked by that employee. The number of piece rate units earned, and any applicable rate that employee is paid. So piece rates have to be on there, number of hours, right? That it worked out to, that they worked at that piece rate's got to be on there. If you're doing any sort of piece rate, whether it's hourly plus piece, so minimum wage or above plus piece, or pure piece rate, which is what most of you do, especially during harvest, you're going to see rest and recovery pay for that entire work week. So a lot of you are skipping that, or you're just paying it on the day. The rest and recovery rate is going to be the same as your regular rate of pay, as long as you don't have a flat sum bonus in there. Non-productive time. If you're doing pure piece rate during harvest, especially, right, I need to see 15 or 20 minutes or so of non-productive time. So a lot of you are leaving that entirely off the list. So that's paid at minimum wage or above. Give me some time. That's walking time. That's picking up my tools. That's getting my instructions for the day. Walking in and out of the field for meal and rest periods. That's on my time. Anytime that employee can't earn piece rate, you're putting non-productive time just during any work week, right, that you're using pure piece rate. Then I'll see non-productive time for those piece rate days. Rest and recovery, I've got to see it for the entire work week. So very big pain there, but it is required. California paid sick leave. No matter how small of an employer you are, you need to have California paid sick leave on your check. If you're front loading and you're depositing 5 days worth on there, then I'd see what's available. If you're accruing, I'm going to see how much is accrued and how much is available for use. If you're doing H-2A, I want to see on that paycheck stub hours offered, right? Hours worked. And those are two separate numbers. Don't try and jam them together. And remember that paid sick leave is paid at a 90-day average or the weekly weighted average, just like you'd pay overtime, not at minimum wage. So getting a perfect paycheck stub is entirely possible. This one just happens to be an example by Data Tech. After some tinkering, we got it right. And those blockouts are showing the grower's name and address on there. And then you're seeing how they broke out non-productive time beautifully, rest and recovery beautifully, hourly pay beautifully, and we took it all into account. When you go to do digits, I like you to see you using 2 digits. Don't flip back and forth between 4, 3, and 2 digits out on decimals, because that tends to create rounding issues. And I'm always afraid that a dumb plaintiff's attorney isn't going to be able to figure that out, because they'll claim everything is a violation and then you have to talk them off the ledge. So I do like to see that all drop down to just a consistent 2 digits. And so sometimes if like ag code's trying to talk to data tech, ag code's using a bunch more digits, data tech's using less, and I'm seeing discrepancies between the two that make it look like it might be wrong. So hours worked, we've got to account for every single minute that our employee is suffered and permitted to work, even if they're not asked to. So if they're picking up bathrooms, if they're getting water and ice, if they're filling out time cards, if they're getting instructions, if they're picking up tools and sharpening them, putting safety gear on, all of that stuff has to be compensable time. And we need to make sure that we are educating our foremen, our supervisors, our employees, that we expect them to put that time down on their time card. It used to be we didn't worry about these little bits of time. We'd call it de minimis. Of course, in California, we lost that fight. The courts are saying now we need to pay down to the minute. So, and that does include donning and doffing time. So time I'm putting on, safety gear, putting on my sprayer outfit, right? Putting on my rain boots if I'm wearing rain gear, not getting dressed at home, right? But if they're coming in, we want to make sure they're clocking in and then they're going to put their stuff on, right? So it's the order of things. And then taking it off on the clock, then clocking out. Okay, so piece rate, right? Any pay period that has piece rate, I've got to see rest and recovery for that entire pay period. And that non-productive time, if it's pure piece rate, is anytime they can't earn piece rate. So very, very troubling spot for us. Rest and recovery periods are your rest break time and your heat illness time, and you're just paying what you're authorizing and permitting them to take. So if you authorized a 10-minute break, but they took 15, you could pay them the 10, that's fine. If they ran over, it's that one we get a little bit of grace for. Same thing with non-productive time. It's our best estimate. That non-productive time could include stretching, exercises, paperwork, getting instructions, putting on gear, and anything above minimum wage is going to be great. We just disclose what we're paying. So here I have a couple examples of piece rate that I wanted to give you guys just to show you how far off we can be very quickly. So if you did 40 hours of work, you did 1,000 units of production, right, at $1,000 a unit, we paid you $1 million. How could you be underpaid? But you are, because of rest and recovery, right? You did 1.67 hours of rest break time during the course of a 40-hour work week is your normal amount. You should have been paid $26,000 an hour for your rest break pay. So we shorted this employee $43,000, right? Any issues there? Oh, yes, because we didn't pull any time out for non-productive time. So here, and this was back when minimum wage was $15.50. We shorted them $19.38 an hour for the time that they couldn't earn their piece rate pay. So they were underpaid yet again. All right. So that kind of ends my, the most common things that I see that are leading to these PAGA lawsuits. If you guys have any questions that I can answer, I'm happy to do so. I'm going to share these slides, of course, following the presentation for you guys. So you'll have this to look over and compare to your paycheck stubs and call it an audit, write it up so you get credit for it, right? I really need you documenting your audits to get that automatic PAGA penalty reduction. In order to get that reduction, you do need to do these audits before you get a request for payroll records, before you get notice of a lawsuit. So, and that will get you that dramatic shift down. The other thing I should mention is that because of new PAGA, because of these changes, and we've got now a few tools back in our toolbox to help you guys with, doesn't make my job necessarily easier, because we have seen the rate that these cases have been filed going up tenfold. So we literally cannot answer the phone. We get locked out on the clients we can accept because we get so many of these. So it does create a giant burden on, I know, our office, because so many are getting filed. So you really have to believe that if you haven't been sued yet, you will, and take proactive steps in doing those periodic audits and then documenting them as an audit, right? And yes, your own internal audits would be discoverable. So careful what you say, but document that you're doing it. All right, so let's see. We've got some Q&As in here. Would you explain the overtime by the week versus the day? What if the overtime is actually on a day and the rest of the week is 8 hours? Okay, so it doesn't matter. So under federal law, if I was working today at $20 an hour, $30 would be my overtime rate. Under California law, it's a weighted average overtime, and you have to look at your entire work week. So a lot of you will say, oh, we just work at one rate. Well, guess what just happened? Did you work over the January 1st, December 31st week? Because there was a minimum wage shift there. There was a rate shift there. you would have had two rates during the course of the same work week. And I've seen that come up in workplaces that would tell me otherwise, gosh, we've only got one rate. It doesn't matter. We don't need to think about this. So, and in that particular case, we had 19 pay periods that we overpaid a guy and 3 we underpaid him. Overall, we overpaid him by over $100. The 3 weeks we underpaid him will mean we cannot get out of that case. So, okay, next question was, do the vineyards worked need to be listed on the paycheck stub itself, or can it be an extra document that comes with the stub? My partner Mike would tell you, by law, it should be on the paycheck stub itself. So there's only about 2 companies that can do that right now. If all else fails and you stick an extra document in to get that information on there, a court hasn't decided that issue, but it does read like it needs to be on the paycheck stub. So I would rather you include that extra document than leave it off entirely. But what I am pushing everyone towards is getting it on the paycheck stub itself. That example that I showed you, add it. So that can be done. Okay. Are you noticing that many government management, many ag management companies are upgrading their in-house payroll software from QuickBooks to DataTech in order to generate compliance statements? Yes. Yes, QuickBooks is not set up to deal with our complicated ag payroll. And so you're trying to round peg, square hole, make it work, right? And it just doesn't work. And so we're ending up giving out all this more information with the check stub itself because we can't get it properly on the paycheck. It's also leading to a lot of errors. So I've had a lot of cases in the last year. We've gotten so much better at what we're doing that we're making a lot of paycheck corrections because it's clunky trying to use QuickBooks and other things. And what's happening is we're not making the change to the time that we're making to the payroll. And so when we go to pull those records and we look at time and we look at payroll, they're not matching. So that's the other tidbit I would give you guys is if you go to do a paycheck correction, you need to document that correction, get the time card updated so that if you have to produce it, which you will, it's going to be able to show matching data between the two. Because that in itself, just with the number of corrections we do in ag, again, led to a sizable settlement. Okay. If we pay the rest and recovery rest period only when we work piece rate work, does that mean I need to record the rest periods all year round for all hourly time as well? No, in fact, you still don't need to record rest periods. That little chart that I gave you in here, look at how many hours the employee worked that day. Assume you gave them all the legally required rest periods. Pay that. That's what shows up on the paycheck stub. You don't need to record rest periods. So even working on piece rate, you don't have to record rest periods. A lot of the plaintiff's attorneys don't know that. And I have challenged them and said, okay, smarty pants, show me in the law where it says we have to record rest periods. And I quickly get that, deer in the headlights look, right? Because there is nowhere that says we must. In fact, read the wage order. It says in there, we do not have to record them. So, okay. Where do we look up a company's legal name that can be used on the paycheck stub? Great question. You can go to the Secretary of State's business search page. The one caution I will give you there is I have a lot of clients who have set up inks who are not using them. So you do want to double check with your client. Hey, I think this is your legal name. Can you confirm? Because a lot of them have set up companies and then don't actively move things over and use them until they get sued and then they wish they did. Right. And so double check with your client, but that is where you would find it. And then remember, we're putting on the paycheck stub, not the ranch location they worked at, but where that company can be sued. So if it's one of the big growers, right, they may have headquarters in Las Vegas or, wherever, Texas. So it could even be that address that's listed on the paycheck, not block A, and the ranch address. It's where they can be served with a lawsuit.
Right.
All
I
right.
think we got all our questions. Thank you so much, Erica. And as a reminder, we will send out this recording along with the slides. So, oh, whoa, whoa.
Couple more. Okay. Sent 4 employees to 8-hour training. At the end of the training, there was a wine social. Dun, dun, dun. The guys put 8 hours of training and 2 hours of attending the wine social, drinking, mingling. Is that wine tasting time paid? Oh, great question. So what you want to do, especially for us in the wine industry, is if people are required to go to an event, it is paid. However, what I typically do is say, hey, you are invited to go to this social event, but you don't need to go. It is not paid time. There's no expectation for you to go. You won't be punished for not going. It's just something you're invited to, like a Christmas party, right? So if you're making clear ahead of time that that is not required of them, and that would be something they're doing on their own for socializing, that's up to them. Otherwise, we would have to pay them if they felt compelled to go to. So, okay, if an employee was laid off and we don't have any plans to bring them back, do we still have to contact them and notify them we're not bringing them back? No, it helps. And hopefully why you're asking me this is because this year we're reducing our employees, right? Everybody's scaling back on the number of employees that they have. So, but what I do want you to do though is if they call back and there isn't work available, I do want you to explain that they haven't been brought back because we've made a reduction in the number of employees and we don't have a spot for them currently. But what I don't want you to do is stick them in a layoff and hope you're not going to hear from them again, because you will. And don't ignore them when they call. Give them as much information as you can. Hey, I don't have any work right now, but check back in 3 weeks. Hey, we've had to reduce our force by 10%. I'm not sure we're going to have work available for you. You may want to see what else you can find, or check back in with me, and then give them a date that they can check back in. An employee said he would sue me for high blood pressure because I provide coffee. Well, the good news is it would be a work comp claim, and I'm pretty sure your carrier is going to deny it. Yeah, that would be frivolous. But keep in mind, though, when an employee has a heart attack at work, that still can be triggering for OSHA reporting. They can try and make a work comp claim. We provide all the information to our carrier and then encourage them to not accept the claim, right? So yeah, in that situation, they can make the claim and they are protected from making the claim. So we can't fire them for it necessarily without some serious work. But do let your carrier know that we're not wanting to accept that claim.
I think every single employee could make that claim then. My
I am
goodness.
definitely cutting out our snack bar. No.
All right. Well, if there are no further questions, then Erica, I assume it's okay. We can provide your email as well. So if it's a more complicated question, you can reach out directly and work with Erica. Thank you all so much for attending. It's been a lot of information. I'm sure
Yes,
we're
a
all
lot.
greatly paranoid now. But much appreciated for your time, and thank you all for coming.
Thank you. And I'll send you right over the slides.
Perfect. All right. Thanks, and take care, everyone. Bye.
Bye.